Thank you so much for joining me in this interview today. I really appreciate you taking the time for this. Could you please introduce yourself and your channel, and in particular, identify any qualifications you have which are relevant to your channel's content?
Great. Well, thank you for having me. My name is Evan Gelobter. I run the YouTube channel Southern Slavery Uncovered. I'm a law professor here in the United States, in the state of Louisiana. And my area of scholarly focus is on the antebellum slave laws and slave codes that maintain and sustain the slavocracy of the antebellum South. And to that end, I have multiple published articles in law review journals from law schools across the United States. I currently have two in the editing process right now. And as I said, that's really been my area of research, is diving into the court decisions, the codes, all of the laws that really maintain the system of African slavery in the antebellum South.
I've noticed your channel does focus, of course, on that legal aspect a lot. What motivated your channel? And in particular, apart from the fact that it's your academic focus, why do you think that people need to understand about this legal system of the antebellum South?
Well, I love this question because there's a lot that actually goes into this. So I really started on this. I've been a law professor now for 6 years. And about 3 or 4 years ago, the Louisiana State Historical Society came to my university, which is a historically Black college and university, and said, 2025 is the 200th anniversary of the Civil Code. Would your faculty or would some of your faculty consider writing articles for the Supreme Court Historical Society? And a few other faculty and I sat there and said, they came to an HBCU and they asked us to write about the Civil Code. Well, for a majority of its existence, the Civil Code codified slavery, African slavery. So that got me started really diving into, especially first in Louisiana, what the law and codes was all about. And then on top of that, one day I was actually sitting with my daughter, who's a sophomore in college now, and we were watching Django Unchained. And at the very end of the movie, the German doctor, signs a piece of paper and says, Broomhilda, you're now free. And I remember turning to my daughter and going, legally that couldn't happen. Right. So I realized that even though we know slavery, of course, is abhorrent and horrible, especially the system of slavery in the United States, not many people are really familiar with the laws and the judicial decisions and opinions that surrounded slavery and what went on. And for me personally, you can read the descriptions of former enslaved people and what they had to say about slavery and all of that. But when you read the judicial opinions, when you read the jurists and the judges who actually created this system, and you really understand how this was based in white supremacy, it brings it to a different level. Because as you've seen, and we've even discussed previously, you now have, especially in today's political climate, this resurgence of neo-Confederates, of Confederate worship, of wanting to bring this, the glory of the Confederacy and the lost cause back. But when you really look at what the Confederacy was created to perpetuate for forever, which is the institution of African slavery, it really puts a spotlight on how horrible the system was. A lot of time, you get witness statements and you hear firsthand accounts of people who have gone through something. And people could argue, well, they're giving you the worst part of it. They were enslaved. Of course, they're going to say how horrible it was. So I took the other view. I went to go look at the lawmakers and what they had to say. And when they say things like the natural condition of people of African descent is to be a slave, there really is no argument then. When the individuals, the people who made the law are clearly telling you it's founded on white supremacy, you can't revise that history. You can't reinterpret that. So as a lawyer and as a law professor, looking at the law of slavery, and going directly to the horse's mouth of these judicial opinions, these judges, these jurists, that for me was a stronger argument to fight neo-Confederates and Confederate worship than just going to the accounts of the enslaved themselves.
Excellent. That's a really great answer and really helps me understand that focus of your channel. So would I be right in saying that one of the important reasons for focusing on the legal aspect is that this legal system helped create or reify the systemic white supremacy and racism? And since that legal system takes so long to dismantle, it's not a question of the slavery period being simply a matter of people with bad opinions, and now we don't have those bad opinions anymore. It's these legal systems which take so long to dismantle and which continued to have effect for so long until they were gradually, only very gradually replaced and had long-term effects. And even when they were gone, resulted in almost a shadow legal system, which is still influenced by those original thoughts and motivations. Am I getting close to the idea you're trying to explain here?
Oh, yeah, I think you nailed it. The way that I put it is like this. The fact that the system of African slavery in the antebellum South and what would eventually become the 11 seceding states that created the Confederacy, the fact that it was based on white supremacy is what led to all of our problems racially post Reconstruction, all the way up into the present day. Because when these jurists were writing, and a lot of times, and I cited in my videos, An Inquiry into the Law of Negro Slavery in the United States by Thomas R. Cobb. And Thomas Cobb was a Southern jurist from Georgia. He was affectionately by the Confederates known as the James Madison of the Confederacy. That's how instrumental he was in writing the Confederate Constitution, as James Madison was with the U.S. Constitution. And he wrote this corpus of slave law in the United States. And he spends hundreds of pages explaining the natural condition of Africans is to be in a state of slavery, of white supremacy, and all that. When the 13th Amendment was ratified in 1865, this racial view, this white supremacy didn't shut off when slavery ended. I'm not a classical scholar. I'm not well versed in Greek or Roman slavery, but I use an example when I try and explain this. And classical, academics going to hate this, but I look to the original Gladiator. And in the original Gladiator movie, the man who ran the gladiator stables, he goes, "I was a slave. Now I'm not. And look at me. Look at what I've accomplished." And that's because, at least in the frame of that movie and what I know of Roman slave laws, slavery wasn't based on race. You were conquered, you were sold, you had debt. But when slavery ended, there wasn't this idea that I am superior to you because we are of a different race, right? In the American system, when slavery ended, you had years of pseudoscience and pseudomedicine and judicial interpretations that had explained that whites are superior. So when slavery was abolished, those attitudes didn't go away. Those men didn't go away. Alexander Stephens, the vice president of the Confederacy, who said the cornerstone of our civilization, the Confederate government, rests on the fact that whites are superior to Africans. He goes on to be the governor of Georgia after the Civil War and a member of the House of Representatives. When you look at the law that codified that Black people were slaves because they were Black, it helps you better understand why that didn't end. And even to this day, if you watch the news and you see a court case and there's an African-American family that's very upset with the decision or the outcome, I look at a lot of my students and I say, people, African-Americans and people who descended from slaves have a right to be cautious of a system that for the majority of its existence considered them either less than human or less than white people and regarded them as different. So I think you nailed it with that.
Thanks a lot. That's great. And it gets back to what I know we've talked about before, helping people understand the concept of systemic racism and how it emerges, how it's perpetuated, and exactly why it takes so long to dismantle and those long-term effects you were talking about. And one of the major issues of systemic, not just systemic racism, but any systemic social ill is its ultimate invisibility, because it's baked into the system such that it's not intangible in its effects, but it's invisible to the people who are in that society because it is just taken for granted. When I explain this, when I'm teaching literature to my students, especially if we're talking about the systemic issue of racism in American society, I like to use the example of Huckleberry Finn, the story very familiar to you, no doubt, and point out that even though Samuel Clemens himself is indisputably an abolitionist, and he is entirely sympathetic to the abolitionist cause, and all his good characters are also devoid of racism. There's young Huckleberry Finn. He's only a 13-year-old boy, and he has a friend who's an escaped slave. So the point of Huck Finn is that he has this small vice, smoking tobacco, and he is fully unconscious of the fact that his tobacco, which he sees as a harmless vice, is in fact the product of slave labor. And that's an example of a systemic oppression. It's so baked into the system that it is transparent even to those who benefit from it. And as you mentioned in your videos, even those white people who were against slavery, even some of the Northerners who were less racist, not being particularly completely racist, still benefited from the systemic oppression of black people because of the economic products that benefited the North. So this is the importance of helping people understand a systemic issue. Moving on, could you describe your research method and what quality control measures you take for your videos?
Sure. So with all of my videos, which are pretty much based off of the publications that I've done in the past, I use, as an attorney, I have access to LexisNexis and Westlaw, which are online resources that have all judicial opinions from all of the states, the circuit courts, Supreme Court, all of that. And it's a tool that attorneys use to do legal research on. So when I want to, let's say, I recently had a paper published on how antebellum slave courts sanctioned cruelty against enslaved people, and how even though there were laws that in theory were meant to limit the power of a master or overseer, many times the courts allowed the violence to exist or continue because you needed, as many judicial opinions had said, you needed absolute submission to the master, or to the person who existed in the master's place, so an overseer or someone on the plantation given the master's authority. So when I want to search for cruelty to enslaved, I can go through any of the slaveholding states. I can look at all these judicial opinions. This is all absolute recorded. It's used in courts of law. We cite to Westlaw all the time, and that's what I use for my research and to make my videos and, of course, my publications. So when I'm citing, or when I'm talking about, Justice A said this in his opinion, it's verbatim what they wrote down in their judicial opinion during the antebellum period. And for all of the court cases that I cite, I usually put the citation in the description box of the videos, which, again, for a layperson, it might be difficult for them to use to find a case. You may not have access to Westlaw or Lexis, but you can use that. You can plug it into Google and usually find a free resource that will at least give you part of the opinion. So it's all out there for the public as well. So I make sure that everything is cited correctly to the appropriate court case that I'm talking about in the videos.
Thanks for that. I do think that in your case, you have an advantage over other history YouTubers insofar as, to a large extent, you're not burdened with the problem of trying to interpret conflicting or vague or ambiguous historical sources. You have black and white evidence for exactly what you're talking about: actual legal cases, judicial rulings, and discussions or commentary from judges. And this gets to an issue that we've discussed previously, the idea of interpreting certain kinds of historical documents, particularly elite history or elite documents produced by the socioeconomic and legal elite, which may give a false impression of society. As you've mentioned previously to me, and I know you've raised in some of your videos, in a lot of cases, the law said one thing, but it was not enforced to the letter or to the spirit and the letter. And in some cases, in fact, from your videos, in many cases, judges found ways of getting around the law, specifically in order to benefit the slaver. So can you talk a little bit more about that?
Sure. So one of the problems that the antebellum slaveholding states and the courts in them had to deal with was this idea of the absolute authority of the master, but also possibly limiting the power of the master, right? We had discussed previously the Somerset decision, which the argument was, do you need positive law for the existence of slavery to exist? Meaning, do you have to have in the state, on the code book, it say, yes, you can have slaves? Did you need that? The antebellum jurists in the slaveholding states said no, because slavery is the natural condition of people of the African race in submission to whites. Therefore, you don't need it. However, there's a flip to this, and this is what's very interesting. They also said, while you don't need positive law to have slaves, you do need positive law to limit the power of the master. Without it, masters could do anything. And they called that absolute slavery, meaning I could kill my enslaved person if I wanted to. And all Southern jurists said that doesn't exist in this country. We have limits on it, but limits have to be applied by the legislature. If not, there is no limit on the authority of the power of the master. But to that end, you did have times where masters, and again, I do want to say for the audience, I use the term master and slave and all of this, and it is very difficult. It's hard to talk about, that human beings were looked at as chattel property. But these are the terms that were used at the time and in the judicial opinions. So it's just, I keep it to just be, to be in line with what was said, and to, so we don't dance around the horror of that. It should be cringeworthy. It should make you uncomfortable. But in some of these decisions, you had, let's say, an overseer had whipped a slave to death, which happened a lot. And these ended up going to court, usually not criminally, but civilly, right? Which shows you the society as well, because this wasn't about someone going to jail. This was about someone trying to recover the money that they invested in an enslaved person. So usually it was owners suing overseers for overstepping their authority. Now, when an overseer or a master did such a thing, such as, let's say, brutally whip a slave to death, the courts had a problem. If they truly did follow the law, which said in many states that you can't abuse or, abuse an enslaved person, and it did put limits on it. But if you agreed with that, if you judge that too narrowly, you would remove the authority of the master, the authority of his agents, the overseers, and then undermine the institution of slavery. So a lot of these judicial opinions, which, by the way, neo-Confederates and people come to my channel and say, Evan, this person got punished for killing his slave. Well, okay, but did you actually read the judicial opinion where it said, yes, in this situation, this overseer, this master went too far? However, if an enslaved person is killed while a reasonable punishment is being meted out, then the person is not criminally or civilly liable. And they always did that. I hate to, hyperbole and say everything or to speak in absolutes here, but in almost every case that I've studied where a court has held someone liable either civilly or criminally for abusing an enslaved person, the court has always left the door open to say, however, if the punishment is reasonable or if the slave refuses to submit, then there is no liability if the enslaved person is killed. And again, who would have been the agent to determine what is reasonable? In this case, an antebellum judge or an antebellum jury full of overseers or masters. So the system was really self-regulating. People only got punished, one, if they damaged someone's enslaved person as property to the point where a master lost a lot of money, and then the system compensated him. But the system was really self-regulating. The limit of the authority of a master, even though there were laws on the books that supposedly limited it, was really determined by the judges and juries that would be looking at these cases.
I'm particularly glad that you raised that because it shows the value of your expertise in interpreting these documents. Because someone like me, for example, could do a search, find the legal rulings and think, oh, wow, gee, I didn't even realize that the South actually did place legal limits on the masters. Looks like things were better than I thought they were. But then, as you've explained, the real issue is how those laws were interpreted, and the documents that you have access to allow you to demonstrate that, in fact, these rulings were often circumvented either in the letter or in the spirit. And another reason why I really appreciate what you've said is because you've raised the issue of the Somerset decision, which we've talked about previously, the late 18th century, I think 1772 decision of a British judge, that since there was no positive law permitting slavery in England, that slavery was therefore by default illegal. And as a result, a slave who had been brought to England was free the moment they set foot in England because there was no legal power to maintain slavery. And as I mentioned to you a while ago, when I first discovered the Somerset decision a long time ago, I was not only surprised by the fact that it was there, given the ongoing use of slavery in the British colonies and Britain's involvement in the slave trade, but I wondered what legal effect it should have had on the colonies in America, because as I understood it, legal judgments in England at that time should have had a legal effect on the 13 colonies, since they were technically inheriting the British legal system. And from what you've mentioned there, it should technically have had an effect, but the legal system in the colonies deliberately took steps to circumvent that. And from our previous discussion, and I think alluded to in your own video on the Somerset decision, you've explained that in order to try and circumvent the legal implications of that decision as it applied to the colonies, the legal system in the colonies appealed to what they considered was a greater authority, and that was the natural state of black people as inherently inferior and inherently slaves. So could you discuss how those legal judgments were constructed specifically to circumvent the Somerset decision on the basis of white supremacy, which gets back to your point that the South was not simply a society with slaves, but a slave society, and that the entire system at its root was based on this concept of white supremacy?
Sure. And this is what I talk about all the time, because when people come to my channel and they say, slavery wasn't about race, it absolutely was based on race. And the Somerset decision is that perfect example, of the foundations of the system. So you've already explained what happened in Somerset. Well, the 13 colonies that would eventually become the original states, the ones that had slaves, the slaveholding states, the colonies had a problem. Right? What do we do now with this ruling from the King's Bench, from Lord Mansfield, that says that slavery is so odious, it goes against the law of nature, therefore, if there's no positive law, it can't exist. And the key is that he said it's odious and that it goes against the law of nature. So, slaveholding jurists just flipped the script. They said, no, we don't need positive law for slavery because it is the natural condition of people of African descent and of the African race. And they went to great lengths to prove this. They, I cite a lot Thomas R. Cobb, who was a famous antebellum jurist from Georgia. The Confederates affectionately called him the James Madison of the Confederacy because he was instrumental in writing the Confederate Constitution, the same as James Madison was in writing the U.S. Constitution. And in his book, An Inquiry into the Law of Negro Slavery in the United States of America, he spends around 100 pages explaining this. And he explains that, according to them, the law of nature says that if I do something to another human being that betters their condition, then it doesn't go against the law of nature. It is permissible. And it is actually better for that person or that individual or that race. So he then goes on to explain, and by the way, just to show you that this isn't just, some book, antebellum Supreme Courts of the states, so like the Alabama State Supreme Court, cited to this book all the time. This was actually used. This was known if you were, a practicing attorney in front of an antebellum court and the issue was slavery, you would use this book to bolster your argument or to do research. So they argued that because Africans and people of African descent are inferior, their condition is bettered by a state of slavery. Therefore, it is natural for them. Therefore, we don't need any law to say we can have slaves. And on the same token here, Thomas Cobb makes a point to say this is why whites can't enslave other whites. Because if white people are equal to each other, then there's no benefit to be gained from enslaving another white person. So again, when people make the argument, slavery wasn't about racism, it wasn't about race. Sure, slavery in other parts of the world may not have been about race, but slavery in the United States was 100% absolutely based on white supremacy and the inferiority, according to them, of people of African descent, because that justified its existence without having to have that law on the books. And then, like I said, the terrifying flip side of that is they made the argument, and the courts agreed, that while you didn't need positive law to have slavery, you did need positive law to limit the authority of the master over enslaved people. So it's interesting to see how they use the same argument, but going down different paths there.
That's really valuable because, as I mentioned in our previous discussion, I've often wondered how the Somerset case should have legally affected the colonies, and that I didn't know because I just didn't have the legal knowledge. And then if it should have, I wondered how they would get around it. How could that have been circumvented? And you've explained that really well. And in particular, this illustrates, as you said before, that the entire system was based not even on a legal judgment, but actually on an ontological concept that African people are fundamentally inferior and their natural state is subjugation to people of what they considered the white race. So the entire system was based on white supremacy. And as I know I've mentioned to you previously, one of the things I like about your channel is that you go back one step further than slavery. So in explaining the Civil War, people point to slavery. But of course, in order to explain slavery, we need to go back one step further. And you do that by demonstrating from the legislation itself that slavery was fundamentally predicated on white supremacy. And as you know, as we've discussed, this is why I've been interested in particular in pseudo-archaeology relating to Atlantis, because in its modern form, Atlantis hunting, not completely, but overwhelmingly, has at its foundation the concept of white supremacy. People sought to explain structures they found which they thought the local people or the ancestors of the local people were too primitive, unintelligent, unsophisticated, uncivilized to have achieved themselves, and therefore these structures and this technology and this knowledge must have derived from the old world and ultimately from an ancient, advanced, high technology race which just happened to be, in most cases, white. So we have intersecting interest in this regard. And in the case of Atlantis studies, it's a matter of something which seems very innocuous. And of course, as I've mentioned myself in my own videos, Atlantis hunting in and of itself is not racist. But one of the fundamental concepts on which it is based, and one of the most commonly appealed to concepts, which is these people couldn't have built this stuff, is fundamentally rooted on the idea that some people are just more intelligent than others, which is just a dangerous idea to have, precisely because it is predicated on the idea that you can make these kind of value judgments. And again, at its root, modern Atlantis hunting does have its origin in colonialism and white supremacy. Moving on to my next question, what do you aim to achieve with your channel?
What motivated my channel is that, my area of scholarly research is on antebellum slave laws and slave codes. And when you actually read what these judges, what these courts had to say, you get an entirely different perspective on the institution of slavery. Of course, we all know slavery was bad. We all know it was horrible. But again, it reads differently when you see it coming from the mouths of the people who created the system and then interpreted the laws of that system. I give the example a lot that in courts of law, we tend to discount witness testimony, not because witnesses are necessarily lying, but human beings are human beings. They tend to either embellish or possibly to not remember situations, 100% or the best that they were. So there have been plenty of people who have looked to the accounts of former enslaved people after the 13th Amendment, after Reconstruction, what they had to say about slavery. A lot of times I get people who come to me and they challenge that. This is the neo-Confederate group again. They say, well, of course a former slave is going to say that it was horrible. Why wouldn't they want to say that it was horrible? You can't trust what they have to say. So my perspective as an attorney and as a law professor and someone who can understand these opinions and the law, I went to go look directly at what these judges and justices had to say, not just at what the law had to say. Like we just talked about, the law could say, for example, you can't maim or abuse a slave. But then how did the courts interpret that? What did they have to say? Because no one can tell me that that justice was lying when he said that absolute submission to the master is what is required of an enslaved person, and that an enslaved person must know that there is no recourse from the will or desire of his master. That's it right there in black and white. So that's what motivated my scholarly research. And now my channel, especially in today's day and age where you do see this resurgence of neo-Confederates, anti-Semitism, neo-Nazis, all of these groups that are now more comfortable coming out, especially with things such as the Trump administration now trying to revert the names of military bases back to Confederate heroes and Confederate generals. I felt that it was necessary to actually put this information out there. I'm in Louisiana. I'm originally from New York, so I'm a carpetbagger down here, but I'm in Louisiana, and we have parishes, not counties. We're the only state that does, but one of our parishes is named Jefferson Davis Parish. So we have a county named after the president of the Confederate States of America, which existed for one purpose: to continue forever the institution of African slavery. So that's why I decided to start my channel, because very few people, except for maybe, my parents, are going to read my articles, that come out in law reviews. And, especially because law reviews, today, a lot of them focus on issues of law that's pertinent to right now. And I've been lucky enough that I've written pieces that have been accepted by law reviews that focus on the history of the slave laws and slave codes. But, very few people that are going to be confronted by this neo-Confederate resurgence are actually going to go read academic papers. So being on YouTube, I felt, would give me an opportunity to reach out to people who wouldn't otherwise normally hear about this stuff.
Excellent. So what responsibilities do you think history YouTubers have?
This, I think, is very important. And I say this because, I've reached out to many people here on YouTube. I reached out to Dr. Flynn Dibble. He gave me some great advice on how to better my channel, what to do, how to make videos. And Milo Rossi, Professor Dave Explains, all of these YouTubers who are science and archaeological educators. But I see a difference between what they do and the history, educators, or the ones who take a history view, and make YouTube videos about that. Because when you're talking about, let's say, evolution, uh, you can have, you can say the evidence here shows, or the evidence here proves A, B, or C. When you talk about archaeology and, Graham Hancock's Atlantean civilization, you can have someone like Dr. Dibble say the evidence shows that this couldn't have happened, because we have the proof here. With history, it's a little different because the term like revisionist history, well, we're always looking back at history and we're interpreting it based on the norms and things we see today. So I may look at a judicial opinion and say, this is what the judge said, and clearly it's bad. But a neo-Confederate or a neo-Nazi will disagree with me, right? Because that neo-Nazi who believes in white supremacy doesn't think this judicial opinion is bad. He thinks it's the right thing. So when it comes to history educators here on YouTube, we can't just to throw the information out there. That's not responsible. We have to also guide the audience through what and I hate to use the term correct, but the correct interpretation of these judicial opinions that show that slavery was based on white supremacy is to come to the conclusion that the antebellum slaveholding states was a slavocracy. You know, I get attacked a lot of, well, people back then, it was a different time, therefore, they were okay with slavery. Well, no, there were people back then who knew slavery was bad too, right? The concept of evolving morality, I think, is nonsense. People knew back then it was bad. There were people who existed who believed slavery was bad, but there were people who thought it was a good thing. There are still people today who think the Confederacy and the antebellum South was a good thing. So history YouTubers and history educators, we put the information out there, but we can't necessarily just say the evidence says you're wrong, right? You almost have to guide the viewer through that and explain it and really lay it out there carefully, because history can constantly be revisited and looked at through the lens of society today. And just look at, the new administration and the way that things are leaning. Like I said, Confederate named military bases. That shouldn't be okay. Well, why shouldn't it be okay? Because these men were fighting to create a country that existed for the sole purpose of continuing forever the institution of African slavery. So I think history YouTubers have a responsibility to not only put the information out there, but to be careful about putting that information out there, and also to be able to guide the viewer through understanding that information correctly.
Excellent. Thanks very much for such a detailed explanation of your view. And that actually leads me to my next question. How do you think that history YouTube can contribute effectively to public history communication? And do you see yourself more as a history communicator or a public historian?
I tend to look at myself as a public historian because I do contribute scholarly works to the field. I'm constantly writing on it. I'm constantly researching these antebellum slave judicial opinions and the laws of the system. And, with that, I also then can put out these videos to educate my viewers on my professional opinion of what this court had to say. And I think that that's an important distinction too, because just a generic YouTuber, anyone can get out here and just throw information out, right? But like we talked about previously, if you want to read a judicial opinion, you need to know how to read a judicial opinion. I wouldn't go to a science educator or an archaeologist here on YouTube and say I can read one of their peer-reviewed papers and necessarily understand it all. So I do defer to their expertise on this. And I think that's the difference, because you get a lot of people, a lot of YouTubers. And, for example, you might have, is it Dan from Debunking? right?
Yes.
I
Yes.
believe the man was a professional electrician, right?
Yes.
Now, I'm not knocking professional electricians.
Mm.
When I was single living in an apartment by myself, my rule was once the last light bulb burned out, I'm going to get a new place, right? We
Yeah.
need people with mechanical skills, right?
Mm.
But he, I believe, lacks the necessary knowledge and background to go through the data that he says he collects and then to give a reasonable interpretation of
Mm.
said data. That's just a YouTuber,
Mm.
right?
Yeah.
I believe that history communicators like what I'm trying to do here are not just putting out the information, but are also saying, look, based on all of this, based on how you read court decisions, based on understanding of the law, understanding, common law. I get law students who, they're college graduates, their first year of law, and they have difficulty sometimes explaining to me three branches of government and the responsibilities of each. So,
Mm.
you have to be able to understand that. So in this situation, like I've said previously, kids here in the United States are taught three branches of government. Legislative branch makes laws, judicial interprets the law. But the
Yep.
judicial branch also makes law. They make law through their opinions. That's common law.
Mm.
A lot of people don't realize that. So when you read a judicial opinion and it says, for example, that if a overseer or master whips a slave to death, but it was in the course of trying to get that enslaved person into subjugation, into submission,
Mm.
that now has the rule of law.
Right.
Even though actual codified law might say you can't kill an enslaved person. So I think that's the difference between simply being a YouTuber and being, a historical communicator, as well as you
Mm.
get, with the archaeologists here on YouTube and the science communicators. They are people who actually have a background in that area and can communicate it effectively, as opposed to just finding information and throwing it out there. I believe that's dangerous. I
Mm.
don't think Graham Hancock is racist. I don't think Dan Dunking or I don't think any of these people are
Mm.
inherently evil or inherently racist, any of those problems. But what they do, I think, is irresponsible. And
Mm.
I think that's the difference between just YouTubing and actually trying to be an effective communicator.
I'd agree. And I like the distinction you're drawing that, I would agree with between a history communicator and a public historian. I see a history communicator is somebody who has the knowledge and some capacity, perhaps credentials or qualifications to interpret, say, secondary literature, secondary sources, and present the professional opinions of historians to the public without making their own personal contributions to the scholarship or personal interpretations, personal contributions to our understanding of the history. So communicating what others have said, systematizing, synthesizing, condensing, and presenting in a more accessible way to the public. Whereas a public historian is somebody who does make original contributions, their own research, maybe also their own scholarly publications, and who also has the ability, the capacity, and perhaps the credentials or qualifications to interpret primary, secondary, and tertiary sources as a historian would. And for that reason, I see myself in the same way as a public historian as you do, since I have made my own contributions to the literature and I have been published. And I do not merely synthesize and systematize information and make it accessible to a public audience, but I've also done my own research myself, my own personal historical research, and made contributions to the broader understanding and broader body of historical knowledge. So, on that point, how do you see your role as interacting with academic history? I know that you mainly deal with the primary sources, since that is your area of expertise and you're particularly well credentialed and qualified to do that. How about the secondary literature, the secondary sources, the interpretations of other scholars? Do you interact with them much? I suppose you must do in your scholarly publications, at least.
Sure, I do. And it's actually interesting. In my scholarly publications, I tend to stay away from secondary sources.
Mm.
And this is really more with what law reviews and law journals are
Mm.
expecting, which is different from peer reviewed journals. Law reviews and law journals are run by law schools. And like I said, they're cited by courts. Attorneys use them in the practice of law. And some of them have very historical focuses to them, which is where I tend to get published in. I try and stay away from secondary sources to kind of go off of what I said before. And this is just my perspective on what makes it more, concrete and horrifying and even appealing to audiences is that I'm not giving anyone else's interpretation of what the law or the judges said. I'm saying this is what they said, this is what was done, and this is how the judges interpreted the law. So personally, of course, I read tons of secondary sources. I'm surrounded by lots of them in my office here. I'm currently reading Roll Jordan Roll: The World the Slaves Made by Eugene Genovese, and it's a great, another scholar who's talking about the antebellum slavocracy and the slave world. I love those sources. But when I personally do it, I tend to focus only on the judicial opinions and the law itself. But again, that's just the way that I've decided to do this. So there is no one, again, to go back, there's no one who can tell me that this didn't actually happen or this wasn't the way that the judges saw it or formulated it. It's there in black and white. And the other thing is it also keeps me honest, right? If a court did say, for example, that, a master couldn't do A, B, or C, you can't ignore that. The same thing in the practice of law. If you're going to court and you're trying to find, precedent to support your decision, you can get disbarred by ignoring precedent that goes against you. You can't just selectively pick and choose what you want to use in your argument. You have to also acknowledge to the court that if there was a decision that went against you. So here, like I said, I try and focus on the primary sources, on the judicial opinions, on the codes and the laws in the antebellum slaveholding states.
Thanks very much for that. It not only illustrates one of the reasons why you focus on the primary sources so much, a couple of the reasons, in fact, but also demonstrates the fact that professionals who go to YouTube or people who have relevant qualifications and academic credentials in the field in which they present in the subjects they cover on their YouTube channel actually have a responsibility and accountability, which other people do not, in particular those who are creating content on subjects in which they are not credentialed or qualified, or of which they have very little knowledge. Not only does their content suffer from their lack of knowledge and their lack of qualifications and their lack of skills, but they benefit from the fact that they are not accountable in the same way that academics are, or somebody with a background in qualification, somebody who actually is connected to a network of professional peers. Flynn, for example, is in the public spotlight, and as a professional archaeologist, he knows that his own peers are also aware of his channel, and he has to be accountable to his peer group. And his peer group will hold him to far higher standards than a random pseudo-archaeologist or pseudo-historian on YouTube without any relevant qualifications in the subjects they're discussing, and more importantly, without a peer group which would hold them to account. The pseudo-archaeology and pseudo-history ecosystem largely relies on, in fact, not critiquing each other, or at least not critiquing each other too much. Yes, it's true that you will see occasionally pseudo-historians and pseudo-archaeologists having some disagreements, but they are rarely serious. They'll critique, okay, you believe that Atlantis was here, I believe Atlantis was here, but we both agree that Atlantis was real, and we both agree that mainstream academia cannot be trusted, and we're the ones who have the real truth. So they critique each other to a certain extent, but not to the extent that their own approach or their own methods are ever called into question, and they are never held to account for their presentation of history. Their peers won't hold them to account because, of course, if anybody did start doing that and everybody else did it, then the entire house of cards would fall down because it couldn't withstand that kind of scrutiny. And I think that from that point of view, it's a lot easier to be a pseudo-historian or a pseudo-archaeologist because your peers aren't going to give you that same kind of scrutiny. They'll disagree with you, maybe disagree with your conclusions, but to a very large extent, with very few exceptions, and there are exceptions, they won't disagree with your methods because they're using the same methods. And to invalidate your methods is to invalidate theirs. And as I mentioned, bring the entire house of cards down. There are a few exceptions. There are people, for example, who are critiqued. There are people who with ideas which some pseudo-historians and pseudo-archaeologists think are way too far out. Dan Richards, for example, prides himself in taking a more rational approach. He doesn't want anything to do with the supernatural stuff or the alien stuff. And to give him credit, he is, I would say, the one prominent Atlantis YouTuber who is the most explicitly and consistently outspoken on racism in the Atlantis hunting community, which he doesn't shy away from and which he has raised. He doesn't like the fact that the community has this association, but he knows it is there. And he made a video on a very large pseudo-anthropologist, Robert Sethi, who's an outright white supremacist, openly white supremacist and racist. He made a video on that, and he received an absolute storm of over 1,000 comments in a few days, many of whom were actually flat out racists saying, well, this isn't fair. You've got your Atlantis view. He's got his view. What's the problem? Why can't you just agree to disagree? And he was defending very strongly his stance against racism in the Atlantis hunting community, for which I commend him, because I think that I've seen that very rarely done. But the point is, of course, that's about as much blowback as Dan is likely to get. He doesn't have to submit himself to the same scrutiny that a professional peer group would give to someone like Flint, for example, or yourself in your profession. Moving to our last question, what do you feel the audience of history YouTube channels should expect from the channels they watch? And how could audience members help encourage best practice with regard to the production of history videos?
I think the audience of history YouTubers should expect professionalism, and also, to connect back to what you said, just previously, they should expect that we are actually putting out information that has been vetted and has actually even been challenged and has been proven to be historical fact. When I write an article for a law review, every single footnote is checked by the editors. Every single reference that I cite to a case or what a judge said or what's in the judicial opinion is checked over and over and over again as it goes through an editing process. And science and archaeology and other historical YouTubers who get published in peer-reviewed journals go through, so much as well to get an article published that shows that they truly know what they're talking about. So for viewers of history on YouTube, anyone can take a camera and put up a screen and make it look pretty. When I make my videos, I'm in my office in my house, and I have recorders behind me, which are the old-fashioned way of keeping judicial opinions. But the funny thing is, I bought those for $1 a piece off an attorney who was closing up his practice, and I just got them for cheap. And when I was during COVID, when I was teaching on Zoom, it made for a nice backdrop. But anyone can do that. Anyone can make a backdrop. Anyone can make a video and start spouting off things as fact. A viewer of anyone who's expounding on history on YouTube should check and should make sure that information is credentialed, or at least has some kind of knowledge or scholarship or background in that area. Is it wrong for, let's say, a college history major who's currently in school to make a YouTube channel? And of course, that's a great thing. We should be doing that. But the viewers should also then challenge what those people put out. I don't mind when, it sounds bad, I don't mind when neo-Confederates and neo-Nazis come to my channel, because they say stuff and that gives me the opportunity to say, you're wrong. Here it is. To go back to what we talked about before, the difference with just talking about history as opposed to science or archaeology is science or archaeology, here are the cold, hard facts. I can prove this existed. I can prove there's a transitional species, something, A, B, or C. With history, this is what happened. How two people interpret it can be very different. So you are going to get people who look at it from a completely different perspective. And to challenge history, I think, is one of the important things. And then to be able to sit there and listen to a response. And that's how you become educated on it. So, for example, when people come to me, slavery wasn't that bad. Okay, well, let's look at what the enslavers themselves had to say. Very rarely did they say how benevolent of an institution it was, until ironically after it ended, when they were trying to circle back and defend the institution of slavery after the 13th Amendment, after the Civil War. So I think, the audiences of YouTubers who put out history need to be aware of who they're listening to. They need to critically listen to it, even if they know, hey, that person's a law professor, that person's a PhD, that person's an archaeologist. Okay, critically listen to it, observe the information, and ask questions, right? There's no shame in asking a question. There is something wrong with being a jerk, and being obnoxious, but asking questions is how we learn. So I think that is, the most important thing for viewers as you're going through YouTube and you're watching videos on history to be aware of. And also that, we all do have our own, personal opinions and interpretations of historical events. So there's that as well. So, just be aware of that. Be aware of the biases that exist. Like the term revisionist history is always being revised. We're always looking back and we're looking at it through the lens, our modern lens. But again, the flip side of that argument is, even in ancient times, there were people who realized slavery was abhorrent and bad. So, it's not an excuse, but it does tell you where your audience is coming from and where that presenter is coming from as well.
I definitely agree. And in particular, I would like to see audiences of history YouTube channels become more critical in their assessment of what they watch. I'm fully aware that some people just want history as some kind of entertainment or edutainment, to be generous. And that's fine. I think that's okay. Some people only want that light content, and I don't have any objection to people putting that out as long as it's not harmful. And I don't have any problem with people watching that. But I do think it's important that people get what they want. If they're looking for the edutainment, then yeah, they should get that. But if they're looking for the serious historical analysis, the facts and rigorous interpretation, then yes, they should get that. And I think it's the responsibility of history YouTubers to identify which form of history they're communicating. And I also think it's the responsibility of audience members to query the channels they watch and to provide a little bit of bottom-up pressure. If you want to know if the channel you're watching is good, ask for its sources. Oh, I noticed you didn't cite your sources. Do you have a list of the references you used? I think that bottom-up pressure could be very effective in just helping some history YouTubers raise the standard of their content, at the same time make their audience a little bit more critical and discerning in their content. It's important that history YouTubers are very transparent about the form of history that they are presenting so that people can know exactly what they are getting. Thank you so much for this interview. I really appreciate the time you've taken. I know we've corresponded quite a lot, and it was great that we actually had this opportunity. Yours is an up-and-coming channel, and I'd really like to see it get more exposure. So I hope this video brings more exposure to it, and people can understand the unique contribution that your channel brings to a very contentious era in history.
I really appreciate the opportunity to be on your channel. I enjoyed this conversation. And yeah, for anyone who's interested in the history of the slave laws and slave codes that sustained and maintained the slavocracy of the antebellum South, I'd appreciate it if you come over to my channel and get involved in the discussion.
Thank you very much.